If I lose, DeFi dies with me. These are the words of Tornado Cash developer Roman Storm, a man at the center of what may be crypto's most important legal case ever. US prosecutors claim Storm was responsible for the open source privacy mixer, laundering funds for criminals, while his defense insists code is independent and immutable contracts can't be policed. Today, we're diving into this legal battle, as the outcome of this case could redraw the line between innovation and illegality across the entire crypto industry, or even beyond. My name is Lewis, and this is one video that you cannot afford to miss. Before we dive into the nitty-gritty of a complicated legal case, let's first look at what Tornado Cash even is. Back in 2019, three Ethereum engineers, Roman Storm, Roman Semenov, and Alexei Pertsev, decided that buying a latte with crypto shouldn't reveal your entire wallet history to the cashier. Their answer was Tornado Cash, an open source mixer that hit mainnet in December 2019 and let anyone cloak the trail between a deposit address and a withdrawal address. Even the devs couldn't follow it once the contracts went live. Here's a basic outline of how it works. You drop ETH into a smart contract cloakroom, receive a cryptographic receipt, then redeem that receipt for ETH from a different, new wallet later. Zero knowledge proofs do the heavy lifting, so all withdrawals emerge from a common pool and no on-chain observer can prove which deposit funded which exit. Storm & Company even seeded admin keys in mid-2020, hard freezing the code so no one, not even themselves, could pause or patch the mixer. For plenty of users, that privacy was perfectly legitimate. Whether it's everyday users who value privacy, whistleblowers getting paid, whales avoiding copy trading bots, or NGOs protecting donors from authoritarian states. But of course, the same tech that enables legitimate use cases can also be used by bad actors. The US Treasury accused Tornado Cash of enabling the laundering of $7 billion in crypto between 2019 and 2022, including facilitating North Korean hackers, the Lazarus Group, to launder about $455 million following the Ronin Bridge hack. The regulatory sledgehammer followed shortly after. On August 8, 2022, the Office of Foreign Asset Control, or OFAC, blacklisted Tornado Cash, effectively making it illegal for US persons to interact with the smart contracts. GitHub even decided to yank the repos the same day. 3 months later, OFAC briefly removed Tornado Cash from the sanctions list, and then it immediately re-added it under both its original cyber authority and a North Korea authority, citing new intelligence. Because the redesignation was simultaneous, sanctions never lapsed. But legal sparring didn't end with the initial sanctions. In November 2024, the US Court of Appeals for the Fifth Circuit ruled that Tornado Cash's immutable smart contract addresses are not quote-unquote property that OFAC can block. And in March this year, the Treasury Department formally took Tornado Cash off its sanctions list, saying the case raised issues about applying financial sanctions to autonomous code. Now, we should note that the mixer's contracts never actually stopped running during the sanctions period. Users simply accessed them through alternative front ends or by calling the contracts directly, an anti-fragile property of immutable code and crypto. But if you want to access the best deals in crypto, there is no alternative. You'll have to check out the Coin Bureau deals page. That's where you'll find sign-up bonuses of up to $100,000, trading fee discounts of up to 50%, and cash back on deposits of up to 75% on crypto exchanges. Now, these deals won't be around for long, so take advantage of them ASAP using the link down below or the QR code on the screen. Now, why does that sanctions saga matter? Well, because it set the stage for Roman Storm's trial, now unfolding in New York City. Prosecutors can convince a jury that a developer should be liable for how strangers use autonomous code. Every privacy tool and DeFi primitive could face similar scrutiny. If they fail, the code is speech doctrine wins. On August 23, 2023, FBI agents arrested Storm at his home near Seattle after a Manhattan grand jury charged him with 3 conspiracies: money laundering, sanctions evasion, and operating an unlicensed money transmitting business, crimes that carry a combined statutory maximum of 45 years. He pleaded not guilty 2 weeks later and secured release on a $2 million bond backed by his house, pending trial before Judge Catherine Polk-Vela. But Roman Storm isn't standing alone in the dock, at least on paper. Co-founder Roman Semenov was indicted the same day, but is still at large, while Dutch developer Alexei Pertsev, first arrested in the Netherlands in 2022, was handed a 64-month prison sentence back in May this year, preview of the prosecution theory now headed stateside. However, we should note that Pertsev is currently under house arrest while he works on his appeal. Prosecutors say that Tornado Cash did far more than preserve privacy. They allege that it washed over $1 billion in tainted crypto, including hundreds of millions siphoned by North Korea's Lazarus Group, and further, that Storm knew it. Storm's rebuttal is well summarized in his aforementioned own words. "If I lose, DeFi dies with me." He posted that line on X in mid-June while complaining that the court was, quote, blocking every expert witness. His lawyers framed the battle as code versus conduct. Tornado's admin keys were destroyed during the May 2020 trusted setup ceremony, so the contracts have been immutable and uncontrollable ever since. Now, the crypto community has rallied behind Storm with real capital. Vitalik Buterin's public gifts now total around 200 ETH. VC firm Paradigm has pledged 1.25 million. The Ethereum Foundation is actively drumming up further support, and many more individuals and entities have come out in support of Storm's fight, either financially or through amicus briefs sent to the court, and those are simply letters voicing strong opinions on the outcome of the case. Financial help is essential. Roman Storm tweeted just 2 days before the trial began that he needed an extra $500K immediately to cover a defense budget that has ballooned to $3.5 million. Thankfully, that $500K came in fast. At the time of making this video, the crowdfund has raised over $2.8 million, about 82% of the target, leaving a shortfall as it stands, but donations, they do keep on coming in. While that call for help echoes out, presiding Judge Vela has drawn some strict lines that will make the defense's efforts considerably more difficult. Earlier this month, she barred lawyers from mentioning the now overturned OFAC sanctions on Tornado Cash, ruling that the sanctions fight would confuse rather than clarify the issues for jurors. The judge likewise limited any sweeping First Amendment arguments, while denying a motion from the defense to exclude references to Lazarus Group, as well as a motion to bar any, quote, inflammatory characterizations of Storm's Torn sales, Torn being the token associated with Tornado Cash. With that backdrop, the trial began with jury selection on Monday, July 14th. Evidence battles are already crackling, and they began even before the jury had been fully sworn in. On day one, the defense tried to keep a trove of private messages, texts Storm allegedly sent to New York venture capitalist, a Bloomberg reporter, plus chats turned over by Dragonfly Capital, out of court. Vela said prosecutors may try to authenticate each record one by one. At the same time, a motion accused the DOJ of using a Telegram snippet out of context. A message asking how to, quote, cash out $600 million in reference to the Ronin Bridge hack was actually a forwarded message from a journalist, a fact Storm's team says the missing metadata would have revealed. The judge denied a blanket suppression, but signaled she'll revisit authenticity when the snippet surfaces at trial. The start of the trial did bring one win for the defense, however, as Judge Vela will allow references to standard practices at rival mixers, just so long as the argument doesn't evolve into an everyone does it shrug. So, how will Storm's lawyers approach this legal battle? Well, much of the defense pivots on the moments back in May 2020 when the Tornado Cash devs relinquished any control over the protocol and published contracts that nobody, Storm included, could pause or patch after deployment. From that minute, they say, Storm couldn't do anything, even if North Korea's Lazarus Group walked in with a sack of stolen ETH. His lawyers consider this as Storm hitting the off switch from his side, and lean on the idea that the code stands alone, arguing that uploading immutable software is more like printing a newspaper than running a money service business. However, they do need to be careful about leaning into a pure code is speech argument, considering the judge's limitations on a sweeping First Amendment argument. Judge Vela has already tested certain elements of these claims in her early rulings. In her denial to dismiss Storm's motion for a case dismissal, the judge said, quote, at this stage in the case, This court cannot simply accept Mr. Storm's narrative that he is being prosecuted merely for writing code. Prosecutors concede that the keys are gone, but insist Storm still had levers. He paid for the public web front end, pushed UI tweaks to GitHub, and held millions in torn government tokens. Their blockchain data will try to prove intent, showing hacked funds splashing through the mixer within hours of the hack and tracing some flows back to a hacker's wallet. The defense likely plans to counter this with its own on-chain analysis. The same clusters, they argue, bounced through Uniswap, Curve, and half a dozen other bridges in the same time frame. So post-tornado proximity is not a smoking gun. Fresh drama just keeps rolling into the case, perhaps most strikingly from a late-added government witness, a convicted hacker who says that he laundered stolen crypto through Tornado Cash and is now cooperating while finishing a federal sentence. The issue is that prosecutors disclosed him only after the witness list deadline, so Storm's lawyers warn that they will likely seek a brief continuance if he testifies. They argue that the hacker's testimony is unfairly prejudicial. That is, it is likely to evoke an angry response from the jurors, and it leaves too little time to prepare, as they would have to comb through any blockchain forensics the government has alongside with the hacker's story. While carefully avoiding a sweeping First Amendment argument, the defense warns jurors to grasp the difference between writing code and controlling money flows. Storm never ran a custodial node, never held users' keys, and never touched deposits. He merely wrote software. Prosecutors aim to show that Storm wasn't just a coder. The indictment itself reads that Storm and co-founder Semenov, quote, paid for critical infrastructure to operate the Tornado Cash services, promoted the Tornado Cash service, and made millions of dollars in profit from operating the Tornado Cash service. And while Judge Fela has barred sweeping First Amendment arguments, she will also explicitly tell jurors that the money transmitter statute doesn't require Storm to have controlled users' funds. With that backdrop, two questions will frame every witness. Did Storm retain enough influence to stop bad actors? And did he want Tornado to serve them? If 12 New Yorkers see a man simply publishing code, the code is speech shield might hold. If they see an active operator behind a privacy cloak, autonomy alone won't save him. Judge Fela has blocked out up to 4 weeks for the Storm trial. Jury selection is behind us, and opening statements are underway at the time of making this video, while the witness list is reportedly big enough to keep testimony going into early August. Most court watchers expect a verdict, though, sometime in mid-August. If Storm is acquitted, he walks free. If the jury convicts on every single count, the statutory ceiling is 45 years, the sum of laundering, sanctions violations, and unlicensed business conspiracies laid out in the 2023 indictment. Sentencing guidelines would almost certainly dial that down, but even a single guilty count could translate to a decade behind bars. In Storm's favor, one of those counts is already slimmer than it looked a month ago. On May 15th, prosecutors dropped the part of the money transmitter charge that said that Storm broke the law simply by not filling out FinCEN registration papers. And, as noted earlier, the fight isn't cheap. Heavy hitters have already shown their financial support, from both the crypto native and VC sides of the crypto sphere. Still, Storm has publicly pleaded for additional funds as the legal battle is estimated to cost around $3.5 million, with some estimates for the final tab, including likely appeals, closer to $4 million. And for viewers who want to help, you can find a link in the description below for the official fundraising campaign to support Storm's defense. And for any viewers based in New York, showing up in the public gallery matters too. Packed benches signal community interest in open source freedom, something the judge cannot instruct the jury to ignore. Those are the numbers, the dates, and the dollars on the table as week 1 begins. Testimonies could still reshuffle the deck, but for now, the calendar is set. The war chest is counting down, and 12 New Yorkers will soon decide how far a line of Solidity code can travel before it crosses US law. And what happens if those jurors decide one way or the other? Where does that leave crypto developers and the crypto market? Well, if the jury decides Roman Storm broke no laws, the first effect may be felt in developer chats rather than on the price charts of privacy coins, although that will likely follow soon after. Lawyers close to the case say an acquittal would remove a lot of the uncertainty over anyone releasing permissionless code since the indictment landed in 2023. VCs such as Paradigm, already financially backing Storm's defense with $1.25 million, argue that a not guilty verdict would show prosecutors cannot turn software authorship itself into a money laundering crime. A court win for Storm would also land against a bullish backdrop. Bitcoin recently reached above $120,000, just as the US House began a self-branded Crypto Week to debate 3 pro-industry bills that promise clearer rules for exchanges, stablecoins, and wallets. One loud cohort of analysts assert that legislative momentum, more than macro tailwinds, is what keeps today's rally alive. Remove the legal overhang around dev liability, and the market could find an extra gear. Tokens associated with privacy-focused projects would likely see a boost, while the devs behind shielded pools and ZK wallet plugins would almost certainly seize the moment to ship some upgrades, confident that publishing immutable contracts will not be treated as a felony. Flip the verdict, though, and the picture darkens. A conviction would hand the Department of Justice a ready-made blueprint for treating open-source maintainers as shadow bankers whenever sanctioned actors touch their code. Analysts warn the precedent would reach far beyond mixers, because any protocol that cannot freeze rogue wallets on demand would suddenly look like legal nitroglycerin, something investors would need to price in. Paradigm founder Matt Huang said, quote, "The prosecution's case threatens to hold software developers criminally liable for the bad acts of third parties, which would have a chilling effect in crypto and beyond." Strong words from someone at the center of the crypto industry. And this theme is already seen in Europe, with Pertsev's conviction, as well as European law enforcement bodies taking a harder look at privacy tools. A 2024 Europol report names mixers such as Tornado Cash and privacy coins as some of the toughest obstacles for crypto investigations, urging member states to invest in stronger forensics, data sharing, and training, without proposing new liability rules for the software developers behind those tools. A US conviction would further validate the position taken by both regulators and prosecutors in Europe. It would potentially nudge builders to strip privacy features, reincorporate offshore, or require KYC even when their contracts never touch client keys. Fundamental rewrite of DeFi's ethos. And markets would feel it too. The current rally at least partly rests on the expectation that Washington is moving towards rules, not bans. A guilty verdict would remind traders that enforcement can still leap ahead of legislation. Even a brief wobble could freeze fresh capital from privacy tech startups, precisely the sector that Tornado Cash once energized. So the jury's choice is really bigger than just one engineer. It is a fork in the road for how innovation and oversight will coexist. Clear Storm, and the industry gains a precedent that encourages experimentation under an emerging legal framework. Convict him, and every Solidity code that is in any way associated with anonymity may need its own legal disclaimer. One way or the other, the echo will travel far beyond that courtroom and into GitHub repos, venture term sheets, and yes, likely into the price of the coins in your portfolio. With the trial now in motion, the crypto community does stand behind Roman Storm in his fight to prove that code itself is not a crime. And over the next few weeks, we'll be hoping the jury sees it the same way, because a guilty verdict would drag crypto farther away from one of its most compelling features, financial self-sovereignty. The stakes are high. But for now, that is all the time that we have for this video. So if you enjoyed it, be sure to give it a like and subscribe down below so that you don't miss our next one. And if you want to learn more about privacy coins such as Monero, you could check out our most recent video on that up here. My name is Lewis. Thank you so much for watching, and I'll see you in the next one. Bye for now.